Alright, so welcome to Jumbo IAS and welcome to UPSC Prelims Phoenix batch. In this batch, we revise entire syllabus for UPSC Prelims examination, both static as well as current affairs. Okay. Now, today's topic of discussion would be related to judiciary and electoral system. Okay. So, all the MCQs that we are going to discuss today would be related to judiciary and electoral system. All the current affairs related to judiciary and electoral system. Okay. You all know that we are in Polity Day 4. So these were the topics, these were the current affairs related topics. So all the current affairs related to these two topics have been already shared with you. I'm assuming that you have gone through those notes and then you are sitting for this lecture. Please go through the notes first and then sit for this lecture. All right. So enough of the introduction. Let's straightway start with question number 1. Okay. So current affairs, polity, day 4. These were our topics: judiciary and elections, electoral system. Okay, so first 10 MCQs will be covered through judiciary, current affairs related to judiciary, and then we'll cover elections. Okay, so let's start with question number 1. Regarding judges' cases and the evolution of collegium system, consider the following statements. The Constitution of India explicitly mandates a collegium system for the appointment of Supreme Court and High Court judges. The third judges' case expanded the collegium for Supreme Court appointments to include the Chief Justice of India and the 4 senior-most judges. In the High Court collegium, the CJI consults with 2 senior-most judges of Supreme Court. Okay. Now look, as far as the Constitution is concerned, Article 124 deals with appointment of Supreme Court judges. And our Constitution is pretty clear. Our Constitution says that President shall appoint judges of the Supreme Court. Okay. It's very simple. But the Constitution says that in appointment of Supreme Court judges, the President shall consult CJI. Okay, Chief Justice of India. Now, the Constitution was, at this position only, the President shall consult. A dispute arose with respect to appointment of judges, and well, it said that is this consultation mandatory or not? Okay, whether President should consult CJI, that is there, but does the advice of CJI binding on the President? That was the disputable question. Okay. So for this particular question, 3 cases were there. They are known as 3 judges' cases. Okay. In the third judge's case, well, in the second also, but in the third judge's case, it was clearly defined that this consultation is binding. Okay. And CJI, while giving his opinion, shall consult 4 senior-most judges of Supreme Court. This was made clear in the judge's case, not the Constitution. So first statement is false. Okay. The third judge's case expanded the collegium for Supreme Court appointments to include CJI plus 4 senior-most judges. Yes, absolutely correct, because in the second judge's case, it was CJI plus 2 senior-most judges. It was expanded to 4. So this is there. But for High Court judges appointment, the collegium is CJI plus 2 senior-most judges. So this is also correct. The correct answer would come out to be B. Alright, next. With reference to proposed memorandum of procedure, consider the following. The government has proposed a search-cum-evaluation committee to vet candidates before the collegium makes its final decision. The primary aim of this committee is to enhance transparency in the judicial appointment process. Okay, now here's the thing. What is the procedure of appointment of judges? Now you're familiar with the collegium system. Okay, so collegium takes the final call, and collegium consists of CJI plus 4 judges. Okay. But what would be the process of choosing candidates? Okay. Will this collegium be provided with a list of candidates from which they have to choose? Okay. The final call is with the collegium, but they would be given a list of candidates. Now, who would provide that list? Well, Ministry of Justice will provide that list. Okay. Now, what is the procedure of providing this list? Who will be on this list? All of this is covered through memorandum of procedure. So under the new memorandum of procedure, what the government would do is, government would form a search-cum-evaluation committee which would check the candidate's background. After checking their background, they would include them in this list, and then this list would be forwarded to collegium, and then collegium will appoint judges from the candidates listed on this list. So who will make this list? Ministry of Justice, through a committee called search-cum-evaluation committee to check their backgrounds. Okay, so first statement is correct. Now, collegium system has been criticized for being non-transparent. Nobody knows how the judges take this decision, what are their opinions. It's a closed door meeting. So it is non-transparent. This is the biggest criticism leveled against collegium system, and that is why many reforms are proposed. In fact, NJAC, National Judicial Appointments Commission, was a reform only. So to add some transparency, this MOP, Memorandum of Procedure, this list system, the search cum evaluation system was added to add some transparency, to give some legitimacy to this system. Okay. So second statement is also correct. The answer would come out to be C. Clear? Okay. Next. Regarding the removal of Supreme Court or High Court judge, which of the following statements are correct? The Constitution uses the term impeachment specifically for removal of judges. A motion for removal in the Lok Sabha requires the signatures of at least 100 members to be initiated. The presiding officer has the discretionary power to admit or reject a removal motion. Now remember this. The Constitution does not use the term impeachment for removal of judges. It only uses the term removal. Removal of judges. Okay? Impeachment is used for president, not for judges. Though popularly we use this term impeachment, but the Constitution uses the term removal. So first statement is false. Now Constitution has given a process for removal of judges. So whenever you have to remove a Supreme Court or High Court judge, you can remove it by a resolution passed by both houses of parliament, okay, with special majority. This is what the Constitution says. But the Constitution also authorizes the parliament to create detailed process. This is what the Constitution says, that with 2/3 majority pass the resolution in both houses. But what should be the process? What is the detailed process? All of this is mentioned in Judges Inquiry Act. Okay? Yes, the Constitution does mention the grounds for removal of judge. Proved misbehavior or incapacity. Proved misbehavior, well, if they have misbehaved like corruption or anything. And incapacity, they are mentally or physically incapable. Okay. Now, Judges Inquiry Act says that, well, to remove a judge, well, a motion can be admitted in either house of the parliament. For Lok Sabha, it requires signatures of 100 members. For Rajya Sabha, it requires 50 members. Okay, so this is correct. Once the motion is admitted, by the way, the presiding officer in Lok Sabha, the speaker, in Rajya Sabha, the chairman, has the power to admit or reject the motion. So if the speaker allows, then only these 100 signatures are valuable. So second statement is also correct. Okay. After the motion is admitted, then a 3-member committee is formed. Okay. This 3-member committee would contain a Supreme Court judge, a High Court judge, and a jurist, and they would inquire into the charges, allegations against the judge. Once the committee finds the judge guilty, then the matter can be put to vote, for which special majority is required. You understand? Okay. All of this is given in Judges Inquiry Act. So the answer to this question would be 2 and 3. Okay. Next. Consider the following about the 3-member inquiry committee constituted under the Judges Inquiry Act. Okay. It consists of Chief Justice of India, High Court Chief Justice, and a distinguished jurist. If the committee finds a judge guilty of proved misbehavior, the parliament must proceed with the vote. Okay. Now look, the 3-member inquiry committee does not have Chief Justice of India, a Supreme Court judge. So this is false. Okay. If the committee finds the judge not guilty, okay, then the matter dies there. Nothing will happen to the judge. But if the committee finds the judge guilty, then the parliament can go to vote. Okay, can vote on this issue. But again, the word can is important. It's not mandatory for them to put the matter to vote and remove the judge. Even after the judge is found guilty, the parliament can decide, let's not proceed with the vote and let the judge be. Okay. So must proceed is not the case. Can proceed. So the answer to this question would be D. None of the above are correct. Okay. Next. Which of the following describes the post-retirement restrictions on judges correctly? There should be some post-retirement restrictions so as to have independence of judiciary. Okay. Otherwise, judges would change their decisions so as to get post-retirement benefits. Okay. This is the reason for that. A retired Supreme Court judge is prohibited from pleading in any court or before any authority in India. A retired High Court judge can plead in the Supreme Court. Plead means being a lawyer in the Supreme Court and in the High Courts where they were not a permanent judge. Okay. So first statement is absolutely correct. The Supreme Court judge after retirement cannot be a lawyer in any case in any court of India. A High Court judge can be a lawyer in Supreme Court or any other high court, not his high court. So this is also correct. The answer would come out to be C. Okay. Next. With reference to National Judicial Appointments Commission verdict, consider the following statements. Now you should know this. Why National Judicial Appointments Commission is important? Well, many people criticized collegium for being non-transparent, non-accountable, everything. So, well, 99th Constitutional Amendment Act was passed and a commission was created called NJAC. National Judicial Appointments Commission, a 6-member commission whose chairman will be CJI, 2 Supreme Court judges, 1 Union Minister of Law and Justice, and 2 appointees from, well, central government. Okay, central government would appoint. This 6-member committee would appoint judges. Now, the idea was that judges shouldn't appoint judges. That is why this 6-member committee, which will have representatives from government also, would appoint judges to create a balance. Well, this NJAC Constitutional Amendment Act, which introduced Article 124A, well, this was declared ultra vires of the Constitution by Supreme Court. Supreme Court declared it null and void. The 99th Constitutional Amendment Act was struck down because the Supreme Court said that it violated the basic structure of the Constitution. And what is the basic structure? Independence of judiciary is part of basic structure of the Constitution. And the court ruled, the 5-judge bench of the court ruled, that NJAC, because it has appointees, members from, well, executive also, this would harm independence of judiciary. So on that basis, though this basis was criticized, but on that basis, it was struck down. The Supreme Court ruled that judicial independence requires the judiciary to have a predominant role in appointments. Yes. They said that NJAC does not give predominant role to judiciary, and by not giving predominant role to judiciary, independence of judiciary is harmed, and independence of judiciary is part of basic structure. So this amendment is unconstitutional. So both are correct. Okay. Next. Regarding Tribunal Reforms Act, consider the following. Okay. Now in our country, apart from Supreme Court, High Courts, District Courts, well, there are various tribunals also. Tribunals are those special courts. For example, there is Income Tax Tribunal, okay, National Company Law Appellate Tribunal, National Company Law Tribunal. There are many tribunals for specialized cases. Now, there was multiplicity of tribunals which caused confusion. So a Tribunal Reforms Act was passed by the government. The Act's primary objective was rationalization of tribunals by merging or abolishing them. Some useless, like Film Certification Tribunal, was abolished and many were merged, so that we have minimum number of tribunals. We don't want to create confusion, yes. But this law was criticized because under this law, the judges in these tribunals or the members of these tribunals, well, central government appoints them, but central government increase their control over these tribunals. Okay. Through this law, central government increased its role in these tribunals, which is why many people objected to this, because they think this violated independence of these tribunals. So the matter went to the Supreme Court, and Supreme Court has expressed concerns regarding the Act's impact on judicial independence. This is also correct. Okay. Again, C. Next. In the context of doctrine of merger, which statement is most accurate? Now listen to me very carefully. You'll understand doctrine of merger. You know, all Supreme Court judgments, all High Court judgments, all lower court judgments are also used. First of all, they are stored, they are saved, and they are used in other cases. So for example, I am fighting a case and my argument is that this should be done. Now the judge would say, how can you say this should be done? This is as per the law. So I would go back and show the judge a High Court judgment saying that in a similar case before, the High Court gave this verdict. So by this logic, whatever I am suggesting is as per the law, you should also give this verdict. So these judgments were used as judicial precedents. Okay, this is important word for you to know, judicial precedents. Now the thing is, doctrine of merger says that when a lower court gives a judgment, then the matter goes for appeal in a High Court, and High Court gives a judgment. This judgment, let's call it judgment 2, judgment 1. Judgment 2 is absorbed in judgment 1. Now this judgment 2 has no separate existence. If anyone is going to show the judgment, they will have to show judgment 1, because now judgment 2 is subsumed under judgment 1. Okay. So it signifies that an order of a lower court or authority loses its independent identity once it's upheld or modified by a higher court. This is doctrine of merger. Right? Next. Remember this, a question can be asked from doctrine of merger. It was in the news.